help
Hey,
you?
Rebecca.
Yes, sir.
Hey, this is Nelson Willis.
Yes, sir. How are you?
Hey, I just got that email that you guys filed 57, and then with a series of exhibits. I sent all of those motions. Those aren't exhibits; those are motions to be filed separately.
I understand your point.
Yeah, they're being buried.
Sir,
Under that form.
Well, I was instructed to process the document that way. That came from the clerk. I have no answer for you other than the question was asked because we were unsure of the specific reliefs that each of your documents was requesting. So that went to the clerk for guidance, and I was instructed to file the document as such.
Yeah, that's not the intention of the filings. They're individual filings. This should be numbered 57, 58, 59, 60, 61.
I understand your request, but those were my instructions, and I have to follow the instructions.
Okay, well, all right. Well, this is obstruction of my case. All right, you guys
Mr.
are denying me my due process.
Mr. Willis, may I?
You're not even filing my documents as I send them in.
Sir, I'm filing as instructed. If there
well,
is
no. You're filing per her interpretation, and that's not fair. That's not what I intended. These were not labeled as Exhibit A. They're not labeled in the email to Pro CA5 email inbox. They are not addressed in that body of that email as exhibits. They're individual filings.
May I suggest that you speak with the case manager if you have any issues with this, because I am processing filings as instructed by the clerk.
Okay, well, you're talking to me now, the plaintiff appellant, okay?
Correct. Yes,
and
sir.
you guys are trying to engineer my case behind my back, okay? And I can't have that happen, all right? I'm building my case strategically, and you guys are trying to undermine me. I'm filing strategically. I have a game plan, and you guys are taking my game plan and saying to hell with his game plan. He is nobody. We are the Fifth Circuit Court.
Okay, sir.
And this is what's happening.
Sir, I cannot.
I'm not being belligerent. I'm defending my rights. I'm standing up for my rights. I don't have anything personally against you or anyone else there. I am protecting my rights as an appellant in this court. And I am being sidelined by this clerk of the court who thinks she knows what I'm doing. And she does not. She has no idea. She needs to file my documents and let the defense reply to them. She has overstepped her bounds, and each one of those filings is to get a hearing on this situation with Document 55, and that is blatantly obvious in every one of those filings, and you treat them as exhibits to bury them. This is obvious collusion and conspiratorial behavior against a plaintiff appellant pro se litigant. And that's exactly what is happening, and it has been done to me through the United States District Court and the 235th District Court. That's where this whole case began, in the 235th District Court of Texas. And then I moved it over when they filed a fraudulent non-suit to evade discovery, which everyone in every court is doing their best to hand on to the false filing of that, the false nature of that non-suit. It is too late. It is beyond a procedural release of that case, and the judge never signed an order. The case, I froze that docket intentionally and moved it to the United States District Court, and what did they do? They went ahead and treated me like I didn't matter and tried to honor a fraudulent non-suit and dismissed my case on a 12b6 based on the false misrepresentation of their interpretation of what a non-suit is and when it should be filed. And that is the bottom line of this appeal, and I will set a precedent with this case, and you guys are trying to undermine me, and now it's out in the open. You filed, and I filed document 56 right after, and it's more evidence of wrongdoing by Judge Danelle Haverkamp, which she denied by 45 and 50, which is all crime. And you're denying my evidence because it relates directly to my case in the 235th District Court and the evasion of discovery and why they evaded discovery. Okay, I'm being treated like a third-class citizen in this court. I am the plaintiff. and I am in control of this case, and you guys are undermining my filings, and I need these filed in order how you receive them individually. They get their own docket number. That's exactly what the email says. Not one word about an exhibit in any of that. And I need this done immediately.
And, sir, I'm afraid that will not happen.
Why not? Give me one valid reason. You're on a recorded line. Give me one valid reason.
Because I was instructed to file the documents as such by the clerk.
Okay, get that clerk on the phone with us right now.
I'm going to have to transfer you to my case manager. I cannot transfer you to the clerk. Case manager is Angelique Tardy. So hold on.
Okay, just get her on the phone with us.
Yes, sir. Yes, sir.
Okay.
I don't have conference availability. I can only transfer you to her. But I will preface
this will not stand. This will not stand. And you're doing what this exactly is, Rebecca, and you know I'm right. You're stalling. This is a stall tactic. You're doing this because May 7th is right around the corner, and you're waiting on the brief, the response to my brief from the defense, and you're doing this as a stall tactic to delay, because now you're making me go back through hoops to get a filing done as I sent them in to you. These are not exhibits. They are motions. The title is motion, not an exhibit. How are you doing this to me with a straight face? How are you deceiving me with a straight face? You go ahead and end this call, Rebecca, because I'm going to come down there to that court. I'm going to drive to your court. I will be there before the 7th. And we will, I demand that you guys immediately get the judges involved. I'm going to finally get the Supreme Court supervisory role initiated in this case. That's exactly what I'm about to file for. A sororatory or however you say it. I'm going to get the Supreme Court supervision on this case right now. You have been notified. And you better escalate this, Rebecca. I swear you better escalate this, because we are not playing games over here, and you are not steering my case. I am in control of my own case, my own destiny, and you guys are trying to undermine my case, and you've already done it blatantly with the clerk order of 55, and you denied 45 and 50, which is clearly related to my case. 1,000% related. That is a bullshit tactic by that clerk court in coordination with the defense and the appellee, the powerful Mr. Adam Aron, and that's what you guys are protecting. And you're protecting Citigroup, you're protecting Ontario Capital, and everything that I have filed is evidence that would trigger a DOJ investigation and a grand jury indictment on everybody listed in this case. And you are subverting my case. You are doing this deliberately, and I have this on record, and this conversation will be aired in court. Thank you very much. And you have been notified. The court is on notice.